Yeah, today I would like I had some initial plans that were a bit updated, and I think the update is really a dialogue with Anna. So without knowing each other presentations, actually, you will see that I will build on many things that she has already said, complement something, or profiting of her having already explained something else. So yeah, I would like to start from this kind of provocation. I remember at the EDPS conference 2020, if I remember correctly, there was this final keynote from the Vice President of the European Commission, Vera Jourova, about the reform of the GDPR. And she said, we have three ways ahead. One way is to have a new GDPR reform, GDPR 2.0, but this is too difficult politically speaking. It's too, and the GDPR is so young. That year was just 4. Now it's 6. It's going to primary school now, and the second way is to just forget about reforming, interpreting what we have in the best way. She mentioned some limits of the GDPR at the moment. For example, the one-stop shop mechanism, I think, for all of you practitioners and us is one of the problems. Then there are other possible problems in implementing some articles, some rights that are not so strong, like the data portability was born as a very weak article in terms of effectiveness. The automated decision-making regulation, of course, has been, how to say, injected of many expectations. Article, well, let's say 14, 15, and 22, that this was quite of unbearable to profit just from Article 22 of the GDPR, not to mention many other things. Consent is so problematic. Freedom of consent, Article 7, 3, alternative between consent and paying for services. This kind of alternative, if data can be commodities, this whole thing. So she said, reform of GDPR difficult. Let's interpret the things as we have, or let's have a series of possible different chirurgical reforms, like very limited, but in place. And I think this is actually what's happened. The GDPR has been reformed. We saw what Anna was presenting about many things that have been updated by this secondary legislation. So I would say maybe we did not see it coming, but we have what Anna Bukta mentioned as digital rule book. I'm mentioning GDPR Plus, or digest of EU data protection rules, just focusing on how the data protection rules were really updated in the last let's say 2.5 years. I would say that from 2022, we had the very first approval of the DGA, the Data Governance Act. And then we had DSA and DMA, and then we have AI Act and DA, the Data Act. Not to mention, because it's too much, the European Health Data Space and other important things. I would like to reflect first about one paradox, but I will show you that my presentation will be mostly on some selected points of reform, including the AI regulation of AI. But something is very interesting. Anna was mentioning that the data protection, fundamental right to data protection, is the only right that is both in the Charter and in the treaty. And still, it's one of the fundamental rights that was built on a previously existing directive. When the Charter of Nice was written, basically the directive of data protection was already there. But the fact that the directive was already there never allowed us to think about what data means, because actually we didn't have a definition of the word data that we just have now with the Data Act. It's kind of funny that we have so many data legislation, and the youngest has a definition of what data is. Also because the Data Act has this broader view of personal, non-personal, commercial interest, private, public, etc. So they needed this reformulation. But in terms of policy making, this is very interesting. So this is something I wanted to say. And also, I really echo what Anna was saying about the shift from the free flow of non-personal data to the Data Act and DGA. So actually, we should remember that both the Data Protection Directive and the GDPR had in their title and the free flow of non-personal data. So the idea that European Union policy making has as always with digital law, which is the stick and the carrot. I regulate, so I give some rules, some prohibition, but I also give you certainty. This is also the AI Act built on that. I give some red flags, but at the same time, I give you predictability on what is permitted and what is not. I give you sandboxes. This is the kind of balances. They were already trying to do that because we have to remember that European Union was built as free market, not as an environment of fundamental rights. Fundamental rights came later. We were first free market. So actually it was already there, but they thought that there was not enough. The narrative was that we have to share more data for some public interest and that there should be this open data approach, etc. So they invented the free flow of non-personal data regulation, which was not so strong in terms of impact. And so the new commission 5 years ago launched Data Act and DGA as something that could give new vibes to this non-personal data, but actually also personal data, free flow. But here I would like to focus on these. I will not give the same time and emphasis to all of them, but to these 8 elements of reforms, silent reforms to the text of the GDPR. I think that this might be something that we will still need to see in terms of fitness check, the compatibility or the prejudice, as Anna was saying, without prejudice too. So the prejudice to the GDPR that these new laws are bringing. Sensitive data processing. And I would say under at least 2 perspectives. So both the DSA and the AI Act can help or can have, how to say, influenced Article 9.2 of the GDPR. AI in general, AI transparency, the rules of consent that Anna was already mentioning, the conflict between the Article 7 of the GDPR with both DMA, so consent for gatekeepers, consent from gatekeepers to users, and also data altruism in the DGA, Data Governance Act. How the automated decision-making regulation has been revolutionized, if it has been revolutionized by the AI Act, the right to data portability, and also something else, like data subject representatives and impact assessment. This is kind of some of the interesting, for me, chapters of reform of the GDPR looking at this new legislation. Let's start with the first, the sensitive data processing. So we had, of course, Article 9.2 with some prohibitions. We know the list of sensitive data, 9.1, and then the prohibitions. The prohibition 9.1 and the exceptions to the prohibition 9.2. Actually, now we have a new lawful basis for, or a better implementation of the existing exception in 9.2, which is the AI Act. The AI Act tells us that we can process more sensitive data. So there's a lawful basis for overcoming the prohibition to debias, I'm simplifying now, but to debias AI. So there was this conflict in the law and computer science community about what to do with bias in AI, what to do to reduce inherent discrimination and biases in AI. And this afternoon there will be Mireille Hildebrand, who strongly contributed to that discussion. So I'm very happy that she will be here. And there was two kind of theories. One was to reduce discrimination, we should process fewer sensitive data. It's better not to know if you are gay, black, Muslim, etc., so that I would know. It's kind of blind approach. But then there was another approach going on in the literature that was suggesting from computer science, for example, but also from law and philosophy, etc., including, for example, a paper of 2014 from Bart Kusters and other papers like Frederick Borgesius, etc., saying we should actually process more sensitive data when it's AI to reduce bias. Why? Because we shouldn't have just a blind approach to people and groups, but we should inject diversity in the training data to avoid that the normal, the stereotypical user is the white, privileged, straight, cisgender, etc. So that was a bit the idea, injecting diversity. The AI Act seems to take the second approach. You can process more sensitive data to train your algorithm to be less biased. It's in the Article 10, the article about the data governance of high-risk AI system. Something else on sensitive data, it's a new prohibition. The DSA, in one of the most politically hot discussion, has a special prohibition for profiling based on sensitive data for behavioral advertisement. So it's Article 26.3. It seems a very, if we read, when we read the DSA, it seems kind of a minor clause, but it's so important. It's one of the most important political achievements of the DSA, that now online behavioral advertising are prohibited if they are based on profiling on sensitive data, of course, from very large online platforms. So it applies just to the very big text, but it's super innovative and interesting, and it's actually adding a new, we can say, prohibition to Article 9.2 of the, or to Article 9 of the GDPR. Moving to the second one, like the second small block of AI transparency of these silent reforms. So, you know, the transparency of AI was something that we already knew from a bit from the GDPR when we talked about profiling and automated decision-making, Article 14 and 15. So actually Article 13F, 14G, and 15H had already this duty for data controllers to communicate logic, the meaningful information about the logic, the significance, and the intended consequences of automated decision-making and profiling, right? Yes, but what to do if the data controller is not the one that can really understand and determine and interpret the automated decision-making logic? And this is what happens. Let's make just a simple example. Today, all your data are processed by a data controller, which is ERA, and ERA is the controller of this data. But what if, for example, there is an AI system to just check who is attending and not attending, to give certification, etc.? The logic in this case would be very simple, because it would be a yes or no algorithm. But what about there is a final test, and this final test is facilitated by AI tools that, you know, it would be just a software bought by some provider of AI. So here the AI Act is giving us something. There is this new Article 13 of the AI Act, which is also imposing to the developers of AI, to the providers of AI, so like Microsoft, Google, OpenAI, etc., to design and develop AI in a way to ensure the transparency and the interpretability of the system for the deployer. And the deployer is ERA in this case that I was mentioning, or university, police, etc. This is something adding to the GDPR. It's not reforming the content of Article 22 or 14, 15, but it's something that is really important for the real effectiveness of those articles, because now we have fewer excuses. Data controllers will have fewer excuses to say, oh, well, I don't know how the system works. It's a black box. Yes, it was a black box, but now the AI Act imposes that if it's a high-risk system, the seller of AI to your data controller should tell something, should make the system interpretable, should make Article 22, Article 15, 14, 13, when they say meaningful information, more easy, more effective. And also human oversight, which is also very interesting. There's a long discussions we cannot start now, but what about the human oversight duties in Article 14? I'm now trying to comment on Article 14 with the computer scientist from Polytechnic University of Milan. We are trying to understand what human oversight is also in legal and technical terms. But don't you see that already the GDPR had something? It's the human involvement, right to human in the loop, Article 22, paragraph 3. Is it the same thing? No, this was kind of a ambiguity that some interpreters at the beginning had, to think that human oversight in the AI Act could change or rewrite the definition of automated decision-making in the GDPR. Why? Because here we are talking about the design process, while the automated decision-making in the GDPR referred to the final decision moment. So it's two different moments. Still, this new human oversight might inform the human in the loop rules in the GDPR, because it might make things either easier or more operational. So these are not conflicts, but implementations that should be kept in mind. Going to consent, there's so much to say, and I don't have time, but Anna already addressed many points about consent. So I will very rapidly just show a summary on this. So we had the GDPR with the specific consent. So consent should be specific, consent should be, of course, informed and free, but also we know that purpose limitation and data minimization apply, of course, also to consent provision. While now we have this data altruism, which seems indeed, as Anna was suggesting, to refer to the idea that if you are implementing very strictly the data minimization, you are a data egoist. If you think that this is data altruism, and it's not my comment, I'm just stealing from Gloria Gonzalez Fuster, who used this comparison or this criticism to the data altruism narrative in an article in Le Soir 3 years ago when we had the first text of the DGA. So first, there's this tension, as Anna was saying, from very purpose-limited consent to more data altruism. Let's give data for research, let's trust research. This is interesting, and also it's changing the approach to the interpretation of Article 7 of the GDPR. But what about something that also Anna was mentioning about the shift from well, let's say the interpretation of Article 7.3 about consent. 7.3 says that consent can never be conditional to the provision of a service. So basically, you can never tell me, at least, well, there are many ways to interpret that difficult paragraph. But we can say, maybe you already know the paragraph. It's basically saying that I can never put consent as conditional for the provision of a service. In other ways, I cannot say, give me consent if you want to access to certain contract, etc. Because that would be not a free consent. Actually, now that article has been interpreted by the Court of Justice in the Meta versus Bundeskartellamt case, there's a very short parenthesis in which the court says, you should give an alternative, and this alternative can be also based on paying a fee, but should be a fair fee. What is fair? Maybe 20 euros per month is not fair. Any reference to Meta is on purpose. But let's go to what the DMA says. The DMA says something similar in a recital. They say to ensure that gatekeepers, and I think now we all know what gatekeepers are. Gatekeepers are, for example, Google, Meta, etc. So all platforms that allow core service providers to act. So they're kind of gatekeepers to other services online. I'm very simplifying here. I'm really simplifying. But to ensure that gatekeepers do not unfairly undermine the contestability of core platform services, gatekeepers should enable end users to freely choose to opt in to data processing and sign-in practices by offering a less personalized but equivalent alternative, and without making the use of the core platform service or certain functionalities conditional upon the end user's consent. What are they saying? That it's okay to put consent conditional to the provision of a service, so paying with your data, as long as there is an alternative in which we don't pay with personalization. This is what to say. The alternative should be equally, it says, let's say, equivalent alternative. What equivalent means? This will be our job and your job to understand. What is this equivalent alternative? For me, it's not equivalent paying 250 euros for my per year for my Instagram account if I want a less personalized, because it's not even an equivalence in the market. But this is open to discussion and debate. So I'm just now setting a lot of provocations that should be maybe addressed in the next years. I have a couple of more points. One is indeed on automated decision making and profiling. So we had this quite general approach in Article 22 saying that we cannot process, we have a right not to be subject to automated decision making if these decisions, so what is the definition? Decisions based solely on automated processing, producing a legal or similarly significant effect. Now the AI Act is putting some red zones and is saying, well, even beyond and in addition to this, we have some decisions that can never be taken, right? And I think this is quite clear. This is evident. We all know this. I'm just putting this on the table for us to visualize. You know, this famous graphic of the European Commission representing the AI Act. I have updated it using the final text. So I changed some of the things in an acceptable risk and high risk. But basically, the general Article 22, now the scope is more restricted because everything that you see in the orange thing is already prohibited. So it's not even meaningful to have a right not to have, not to be subject to social scoring, because social scoring is prohibited forever. So just to say that Article 5 informs the scope of Article 5 of the AI Act, informs the scope of Article 22 of the GDPR. How much time I still have, Magda? I can, 10 minutes? 5? 5? Okay.
Well, up to 10, but then we have a little bit shorter.
Yeah. Okay. About data portability, Anna was already mentioning that there's a shift from Article 20 to the new data portability in the Digital Markets Act. So I was one of the scholars who had the privilege to comment data portability in 2017, 1 year after the GDPR, and we were kind of optimistic, but actually not so much. Article 20 of the GDPR has many limits. Data portability in the GDPR is just the possibility to have a copy of the data in a machine-readable version. And then maybe you can ask, if possible, to transfer from data controller A to data controller B. Not exactly the idea of having interoperable profiles and accounts from Facebook to a more, I don't know, a smaller SME producing also social media or something like that. The DMA, and as Anna was saying, the scope here is more restricted because we are just speaking about dominant market. We are speaking about gatekeepers, core service providers, so it's not applying to all. The DMA is giving some more spice and substance to data portability. We have the new Article 9 of the DMA that actually is adding a better right to data portability, much more robust than Article 20 of the GDPR. They say the gatekeeper shall provide end users and third parties authorized by an end user at their request and free of charge with effective portability of data provided by the end users or generated through the activity of the end user in the context of the use of the relevant core platform service, including by providing tools to facilitate the effective exercise of data portability. It's a lot, many words, but more than just a right to receive a copy of your data. That was the Article 20. And I'm simplifying here also because we don't have much time. So the final two things are data subject representatives and impact assessment. I think data, so Anna was mentioning the data intermediaries. That is also something very relevant and interesting. But I wanted to address another aspect of the data, of the DGA, the Data Governance Act. So we had this problem of lack of power of data subjects in representing their own positions, right? So we see this as a problem. We don't contest data controller decision because we might feel powerless. The GDPR is was giving this new role of data subject representatives. Article 80 defines data subject representatives as some entities. Well, there's a long definition of which entities can be considered, but entities having a right to represent. In procedural rights, so in litigation, they can represent data subjects. The delusion here, the disappointment here was the Article 80 does not allow to mandate substantive rights. It just allows to mandate right to lodge a complaint to the Data Protection Authority, right to have a compensation. It's kind of a big lawyer of data protection, someone that helps data subjects to have their compensation or to complain, etc. The Article 2 of the Data Governance Act adds something very interesting, which is not the data intermediaries, but is the data cooperatives. There's not much, but at least there's a definition. These data cooperatives, I see them as data unions. So the trade unions of data subjects. They say that they are organizational structure constituted by data subjects. So kind of a group of data subjects having as its main objectives to support its members in the exercise of their rights with respect to certain data. But look also with regard to making informed choices before consenting to data processing, exchanging view on data processing purposes and conditions that would best represent the interests of its members in relation to their data, and to negotiate terms and conditions for data processing on behalf of their member. Basically, they are not just someone that helps at the court level or the DPA level. They are someone that can empower the powerlessness of data subjects when they have to negotiate with the data controller. It's a way maybe to overcome these limits of notice and consent. It's too late, consent fatigue, we are just one. Here now we might have these cooperatives that we might delegate our interest to consent or not consent, or right to object, right to withdraw consent to these data cooperatives. There are many problems how these data cooperatives will exist, who will pay for them. This is the business model of data cooperatives is very interesting, because if they are then funded by the data controllers, there's kind of a blackout. But if there are public money, or they are self-sustained, like trade unions are, if we can make the comparison, trade unions are paid by workers and by the state. There are different forms of subsidiation. Okay, I think we don't have time for the impact assessment part, but very rapidly, just to say that there are many things that I had prepared, basically the DPIA also is something that has been modified by this new impact assessment. This would require another 30 minutes at least, so I will spare this because there's lunch in a few minutes. But just to say that the impact assessment definition of the GDPR is firstly modified in the definition of risk to a right, because we have the DSA impact assessment, Article 34, that doesn't refer merely to risk to a right. You have Mireille Hildebrand presenting on this topic this afternoon. What is risk to a right? So I will just launch this for later. But the DSA and the AI Act have different definition. They say actual or foreseeable negative effects for the exercise of fundamental rights, or risk of adverse impact on fundamental rights, for example. And then compared to the structure of the impact assessment of the DPIA, I think Article 34, so the DSA impact assessment, is much better, because it has the duty that it must be done once per year. And the DPIA is just when new risks arise. It should have an external audit, the impact assessment in the DSA. The report should be public, while for the DPIA, it's just a best practice, but it's not mandatory. And also, it's much more clear what impact to fundamental right means. If you look that there's a list, letter B here. And I will just conclude with Fria in the GDPR, in the AI Act. We don't have time to address this, but just to say that it was a long fight. This is also personal anecdote. It was very hard to have something in the AI Act about fundamental right impact assessment. The Commission at the beginning didn't want to add fundamental right impact assessment. The Commission just had the risk assessment for AI developer, but they had nothing for the AI deployer. But you see, what if the AI developer doesn't know the application of AI system? They are, for example, I was mentioning Microsoft, Meta, or OpenAI. They don't know that their system might be used by police at the border. It's the border authority that knows the risk and should adapt the risk. And DPIA is not enough. Even though we can have a broad approach of DPIA, all fundamental rights when personal data are at issue, it's not enough for all the risk that AI can bring. So the European trialogue, the European Union trialogue was trying to limit this proposal of fundamental right impact assessment to just public authorities. We managed to have it for, why I say we, because NGOs, but also the Brussels Privacy Hub, we pioneered the letter for 150 professors that would push for a better fundamental right impact assessment that could be also for private entities, that could have representative of data subjects and end users represented. It's in the preamble, but it's there. So it's not the best achievement, but we achieved something. And also it's this participatory approach and some report, and including the notification to the authority. So there's a lot, but good news is that we will organize some events in Leiden on this. So if you're curious, I'm just putting here, we are organizing a conference in summer school on these topics. Sorry if I used this, but it was something just to mention. Okay, thank you.